falling in Kenya, it is the business of this honorable court to protect the prevailing constitutional order, which in the first instance requires it to ensure that the fresh presidential election scheduled to be held on 26th of October 2017 will go on and the results declared notwithstanding challenges wrought by willful act of sabotage and criminality. Emphasis and end of quote. As I have pointed out, it is precisely because of the kind of submissions made and the prayers sought that bring to the fore the question of the jurisdiction of this court to determine the petition and grant the prayer sought. It must be clear that this court is not in charge of presidential election and cannot therefore say anything about the legality, validity, or otherwise of the fresh presidential election at this stage or thereafter without appearing to encroach on the jurisdiction of the Supreme Court. This court is bound by the Constitution and judicial precedents and must therefore play within its theater of operation. I perfectly understand the petitioner's concerns as captured in his petition and from submissions by his counsel. They paint a picture of uncertainty and desperation, not sure of what will happen on 26th of October 2017. However, this court can only exercise jurisdiction as conferred on it by the Constitution and the law, and only when it is properly seized of a matter can it render itself on it. That is perhaps why Mr. Wambua Kilonzo, learned counsel of IEBC, in his submission, correctly cautioned that this court should be cautious on the kind of prayers to grant, pointing out as he did that the prayers in the petition were based on conjecture. He also contended that some of the prayers sought belonged to the Supreme Court. I entirely agree with the learned counsel that the issues in this petition do not belong to this court. This court has a wide jurisdiction to deal with constitutional issues, but they must be real constitutional issues falling within the jurisdiction of the court. It cannot extend its jurisdiction, though through craft of interpretation. Finally, I must point out that during the hearing of the petition, even in the absence of the first to ninth respondent, all counsel present from Mr. Kibe Mungai, Mr. Wambua Kilonzo, Ms. Kitiri, to Mr. Macharia were unanimous that no one can be forced to run in an election. With that concession, I do not know how this court, even if it were to assume jurisdiction, could have forced the sixth and seventh respondent to comply with the judgment of the Supreme Court, even though they were the successful parties before that court, by running in the fresh election. To my mind, no court can force a citizen, or a person for that matter, to exercise his or her right under fundamental freedoms. In the same breath, Article 38 of the Constitution grants citizens the right to make political choices. Under Sub-Article 3C, an adult citizen has the right to be a candidate for a public office or office within a political party, and if elected, to hold that office. That is a political choice to be made by the citizen. It is his basic right and fundamental freedom that cannot be enjoyed and exercised can only be enjoyed and exercised by the individual, and no one, not even the court, by an order of this court, can force or coerce one to exercise the right. That would in itself be a violation of that person's right to make a choice. In conclusion, therefore, having given due consideration to this matter, I am not satisfied that it meets the threshold of a constitutional petition. The issues raised therein, though couched as constitutional questions, fall outside the mandate of this court. The upshot is that the petition dated the 2nd of October 2017 falls by the wayside and is dismissed with no order as to causes.